Appellant Mr. Britt, and if I may, Your Honor, I would like to reserve 3 minutes for rebuttal, please.
3 minutes is granted.
Thank you. Unless the court would prefer otherwise, I would like to submit issues 1, 3, and 4 on the brief and instead focus solely on issue 2, which is the prosecutorial misconduct issue. As this court knows, in considering a claim of prosecutorial misconduct, this court applies a two-part test. The first step is determining whether the complaint of conduct was outside the wide latitude allowed a prosecutor in commenting on the evidence. The second part of the test is the question of whether the remarks constituted plain error, that is, did they prejudice the defendant and deny him a fair trial? This court applies then a 3-part test to that second part of the 2-part test and asks, first, was the misconduct gross and flagrant? Second, did it demonstrate ill will on the part of the prosecutor? And third, was the evidence so direct and overwhelming that the evidence likely had little impact on the minds of the jurors? That third factor, of course, can't override the other 2 factors unless the state proves, beyond a reasonable doubt, that there is no reasonable possibility that the error affected the verdict. In the present case, the prosecutor went beyond the wide latitude allowed on 3 separate occasions. First, by twisting logic to appeal to the jurors' emotions by suggesting that if they didn't convict Mr. Britt, they would essentially be saying the AC was a lying, manipulative, conniving, creative, vindictive, evil child. Second, by suggesting that a defense witness would lie for money by stating that he was, quote, a paid defense witness, period. And 3, by telling the jurors that the right thing to do was to convict Mr. Britt. The state argues that the prosecutor's remarks regarding the jury only having 2 possible choices here were actually accurate because even in the possible scenarios that Mr. Britt has suggested in his brief, AC's testimony would still be false, thereby making her a liar. Even if her testimony was false, however, it wouldn't mean that she was manipulative, conniving, creative, vindictive, and evil. She may have been the one being manipulated, not necessarily the one doing the manipulating. And even if she was lying, it wouldn't necessarily make her evil or conniving. It might simply make her confused, scared, or seeking attention. Thus, contrary to the argument in the state's brief, the prosecutor's comments about the jury only having 2 choices in this case did in fact misstate the jury's options. As to the statements regarding Dr. Logan's credibility, the state cites to State v. Jones for the proposition that a prosecutor may expose bias or motive for testifying by pointing out that a witness is paid for his or her testimony. But in Jones, the prosecutor explicitly stated that the jury could consider the fact that the expert witness was being paid for his or her testimony in judging that witness's credibility. In the present case, however, the prosecutor said, Dr. Logan is a paid defense witness, period. This indicated to the jury that the fact that he was being paid was the only factor that the jury ought to consider in determining his credibility, i.e. that fact was determinative in judging his credibility. Thus, again, the facts in this case are distinguishable from those in Jones. Finally, as to the comment regarding whether convicting Mr. Britt would be the right thing to do, the state decided to State v. Nguyen, in which the prosecutor told the jury that the state would be asking them to bring back a verdict that the evidence in the case demanded, and that would be a verdict of guilty. But in Nguyen, the defendant did not argue that the prosecutor's statements either violated the rule against stating a personal opinion or against stating the justness of a cause or the guilt or innocence of the accused. In that case, the defendant argued only that the comment played to the sympathy of the jury by asking for justice for the victim. So any language in Nguyen on that point is merely dicta. More importantly, I think, the prosecutor in Nguyen prefaced his comment specifically with a statement that the evidence in that case would call for a verdict of guilty. That is, justice would require that verdict because the evidence supported it. And as this court pointed out in that case, a verdict supported by the evidence is the very essence of justice. In the present case, however, the prosecutor did not preface his remark with a statement about the evidence. He prefaced his remark only with a comment about common sense, and just because a verdict is supported by common sense does not make it a right verdict or a just verdict. Finally, in telling the jury that convicting Mr. Britt was the, quote, right thing to do, the prosecutor not only expressed a personal belief about the defendant's guilt, but he also indicated to the jury that they would be doing something morally wrong if they failed to convict Mr. Britt. So the comment and the defendant's argument in this case are very different from the comment and the defendant's argument in Nguyen, making the holding in Nguyen inapplicable. Moving on to the Plein Air Test, the conduct here was gross and flagrant, forcing the jury to decide between a finding of guilt and a finding that this child is manipulative, vindictive, and evil is prejudicial because the jury couldn't help but feel sympathy for this child, even if they weren't convinced beyond a reasonable doubt that Mr. Britt was guilty. Putting them into that position where those were the jurors' only two options did prejudice Mr. Britt. The comment about Dr. Logan's credibility was similarly gross and flagrant because credibility was the key issue, the only issue for the jury to decide in this case. There were no eyewitnesses to the crimes. There was no physical evidence to corroborate the testimony. The only issue for the jury to decide was whether AC was telling the truth, and that is exactly what Dr. Logan's testimony went to. Finally, the personal opinion regarding the defendant's guilt was gross and flagrant because it did place the prestige of the state behind the prosecutor's personal assurances. These three comments also demonstrated ill will. The prosecutor knew, or at the very least should have known, better than to comment on the credibility of any of the witnesses or to convey a personal opinion as to the defendant's guilt. This court has repeatedly held that those are improper. As to the comments about the child perhaps being evil or vindictive, the prosecutor made those comments repeatedly, demonstrating ill will, going so far as to tell the jury, go in there and decide, is she an evil, conniving child, or is she the victim of a sex crime? Even if the evidence in this case were overwhelming, which it certainly isn't, the state in this case has really only made a very cursory attempt to demonstrate beyond a reasonable doubt that there was no reasonable possibility that the error affected the verdict. In one paragraph, the state simply claims, without providing any support, that the statements didn't prejudice Mr. Britt or deny him a fair trial. The state then dedicates one paragraph to discussing Huerta Alvarez, and then 8 lines of text to recounting how long the jury deliberated and what testimony it wanted read back. The state made no effort whatsoever to discuss the evidence against Mr. Britt or to discuss how the prosecutor's comments may have impacted the jury. And the one case that the state did cite was clearly distinguishable from the present case. In Huerta Alvarez, the prosecutor made only one comment that the court found to be improper. It had nothing to do with the key issue in that case. The court determined that it wasn't gross or flagrant and demonstrated ill will, and the testimony of the victim in that case was at least consistent as to the 3 events that supported the charges. Here we don't even have that. AC's testimony varied considerably, especially on I think a key point that one would think would be pretty memorable, which would be whether or not Mr. Britt actually ever made contact with or penetrated her female sex organ with his female sex organ. So under those circumstances, Your Honors, I would argue that this court must reverse Mr. Britt's conviction.
Do we have any further questions of counsel?
On the alternative means after Brown, the only one you might have left would be on the oral sodomy, female versus male genitalia. Would you agree with that?
If Brown was correctly decided, yes, that is, I think, the only argument still standing after Brown.
Anything further? Thank you, counsel.
Thank you, Your Honors.
May it please the court, the state appears by Stephen Obermeyer. With regard to the closing argument issue, the state's primary contention is that the comments in closing argument were within the wide latitude allowed the prosecution in discussing the evidence. And why do I say that? Well, we've had closing argument misconduct case law for about 10 years at least. And while there's not the requirement of an objection, we have defense counsel not objecting, we have the state or the trial court not interjecting, and it's been on the radar for about a decade. Defense counsel closed by saying, I hope you find the defendant guilty. Similar to the third complained of comment in this case. But getting beyond that, as to the first closing argument issue, the victim, you have testimony of 2 witnesses. The victim, age 9 at the time, age 11 at the time she testified, 9 at the time of the offense, and the defendant. And we have to look at closing arguments in context where the state starts off in the first closing by saying, it's up to you, jury, to weigh the credibility of the witnesses, and I'm asking you to assess the credibility of 9-year-old AC in this case. And goes through to argue that her testimony is what it was because she experienced it, and she has this knowledge beyond her years for a 9-year-old who's not sophisticated in things like intercourse and sodomy. She lived it. Now, the defendant's closing argument was that, well, I'm not suggesting that she is manipulative. I'm just suggesting that she was manipulated by mom who put her up to this. And so the state's second closing was, okay, so we have the mom telling her to describe all these factual details, which are in the blue briefs concerning what her experiences were, and her reaction that the jury could see on the videotape that the mom put her up to doing that. And the jury can look at that in assessing the credibility. And there's no comment made concerning prosecutors' belief as to credibility as to victim or defendant or anybody. In addition, we have the jury being instructed that it could use its common knowledge and experience and determine the weight and credit of the witnesses, which it knew its job was.
Mr. Obermeyer?
Yes.
I'm not understanding how you can justify the prosecutor's statement that there was only two ways to look at this. Either she's telling the truth, the victim was, or she was a lying, manipulative, conniving, creative, vindictive, evil child. There's a lot of other ways to look at it, isn't it? And one of them is that she was being manipulated, not she was I can't say that word, manipulative. And like you just said, that was part of the defense. I mean, isn't this an absolute misstatement? Couldn't they have said, well, she maybe just didn't recall correctly, or maybe she was lying about a part of it and telling the truth about a part of it, or maybe she was manipulated about a part of it but wasn't about another part. There's lots of possible gray areas in there, and it's not true, is it, that they have to view it one way or the other?
Well, I'm not sure there's gray area, just because either she's telling the truth or she's not telling the truth. You
just said that part of the defense was that she was being manipulated. Now, it's up to the jury whether they believe that defense, but they might have believed it. Do you see what I'm saying?
And if she's manipulated and making up this story, then she's not telling the truth.
But does that make her lying, manipulative, conniving, creative, and vindictive if she's manipulated? Because that's what he said.
Well, she doesn't have to be all of those things. I think the prosecutor's trying to illustrate that either she's telling the truth or some other external factors prompted her to testify falsely. And that was the issue, contrasted with the defendant's testimony that didn't happen, I didn't do it. I think that's just pointing out that either you believe her or you don't believe her. And
that's not true. I'm sorry. Few cases are black and white. You can have three people that view the same car accident and they describe it differently. Are they either telling the truth or lying when they don't match, when the stories don't match? No, they aren't. And you know, the black and white argument, I could give you the argument she's either telling the truth or she's not, albeit we in the profession know that isn't true when we look at eyewitnesses and other witnesses. But when you ascribe a character trait based on their testimony, evil, whatever, to me you've jumped outside the bounds of fair comment. Tell me why that isn't outside the bounds of fair comment.
Well, I would say that unlike a witness to a car accident, most 9-year-olds aren't sodomized and aren't raped and aren't victims of aggravated indecent liberties with a child. So either she's testifying to what she experienced because she experienced it, or she's not. And the reason she would not be would be for the various reasons. It wouldn't have to be all of them, but it would be some. It would be unlike a car accident. It just wouldn't happen that you'd have the rape or the sodomy. So I think that's a little bit different. But
it's obviously factually different. But the logic of your response to that question was that if a person looks guilty enough and the crime is horrible enough, that the rules don't matter. And I know that you don't really mean that, do you, Mr. Obermeyer?
No, the rules matter, but I think that
So the question was, is it appropriate argument for a prosecutor not only to say she's either telling the truth or she's lying, which is a pretty vanilla statement, versus is it okay to go the next step and ascribe character traits if there's a lie? That was Justice Johnson's question, and I think your response really didn't meet that question.
Okay.
Is it okay to take that extra step?
As far as why she would not be telling the truth?
Ascribe all these very negative character traits to her, that the jury has only two choices, a guilty verdict or they have to say lots of bad things about this little girl. That was the choice they were presented with by the prosecutor, and I'm just asking, is that appropriate argument?
I think the general point can be made that either she's telling the truth or she's not telling the truth.
I'm talking about the next step.
I think that you could say, why would she be testifying falsely? Is it for one of these other various reasons that she was manipulated, or one of those other reasons that could be discussed? But the closing argument started with reviewing the instructions. Jury determines weight and credit, right to use common knowledge and experience, can weigh the credibility, and whether 9-year-old AC is testifying to this because she lived those things or because she was manipulated by her mom, which was the defendant's closing argument. With regard to the second comment, the state said that the defendant's expert was paid. And so from that, we're ascribing all these horrible things. Just like State versus in re care and treatment of Ward, which is very different. Justice Johnson, you were on that panel. The state talked about the defense expert that he would commit perjury if paid to do so. That he would testify that 2 + 2 = 5 if he were asked to. In this case, the comment was, keep in mind the defendant's expert was. The comment was the defendant's expert was paid, and the doctor told the jury things that you, jury, are smart enough to determine in looking at the videotape. There's no statement of personal belief as to credibility of the witness. There's no statement that the witness testified falsely for money. There's nothing wrong with that statement. With regard to the third comment, I cited Nguyen because I thought it was pretty similar as far as the closing, that go back and put your heads together, and the verdict of justice requires is guilty of first-degree murder. Again, this was following the defendant's closing argument that I think you will come back with a not guilty verdict on all 3 counts. So predicting what you think the jury is going to do is somehow misconduct, and I don't think that it is. As to the harmlessness, if I'm wrong on any of those, a couple of things. Defense counsel argued that there was no evidence that the defendant was over 18. The jury asked about 3 questions over the course of its deliberations, which were 3 or 4 hours. Is the fact that he's in this court proof that he's over the age of 18? Is one of their questions. The other was, we'd like the portion of the testimony pertaining to his age, and we want victim's testimony referring to all sexual and or physical contact, and can we have a copy of AC and mom's testimony? If this is such a horrendous closing argument, why aren't you coming back within an hour guilty? Why are you considering whether the evidence supports that he was over 18 or anything like that? So I think I don't think it's inappropriate. To the extent that it was, I think it's a harmless error. With regard to the first issue, we've had a lot of cases over the years. Major cases, and State versus Wright is one of those. And I think the court's opinion on Friday that came down in Brown pretty much addresses the alternate means issue, that just because the word or is in a statute doesn't mean that it's an alternative means. And
Mr. Obermeyer, it seems like what's shaken out today on the cases that we've had on oral sodomy, the real question is, does the fact that it was performed on the female genitalia versus male genitalia constitute a sufficiently distinct or intentional element of the crime, or just describe how you prove the oral?
I think that the definition of sodomy in the aggravated criminal sodomy statute just gives the alternative. It defines sodomy, and I would direct the court to syllabus 10 of Brown that says options within a definitional statutory language that elaborates on the elements does not raise an alternative means issue. So I would say that it's not an alternative means issue, that when you look at aggravated criminal sodomy in that statute, 213504, there are about 3 different subsections, and there's, three different sections on how you can commit that crime. Within subsection 2, there's 2 different subsections. Within subsection 3, there's 2 different subsections, many of which have different severity levels. So we know these are all alternative means because you're getting a different punishment for doing these different things. But again, I think it's a definitional issue that was proposed by the defense. All of these instructions, I've argued, invited error because defense counsel proposed pretty much the same instruction. The only difference being reference of the defendant's name in the defendant's proposed instructions versus the defendant in the jury instructions. So we're to say that defense counsel can say, hey, judge, use these instructions. So I can go on appeal and complain about them when my client's convicted. I cited, I think State versus McCoy talks about invited error in the jury instruction context, and I think that would apply in this case. I see these alternative means issues as a jury instruction issue and not a super sufficiency of evidence issue. Are the instructions incorrect? Are the instructions proposed by the defense counsel clearly erroneous if you get to that issue? And not whether or not there's sufficient evidence. And State versus ICE handles it that way, and State versus Timley handles it that way. It was a jury instruction issue. It's nothing new. Unless the court has any other questions, I would ask you to affirm the conviction. I concede that the remand, or that there would be the post-release supervision part is inaccurate. I concede error on that, but as to the rest, I would ask you to affirm.
Any further questions of counsel? I see none. Thank you, counsel. You deserve 3 minutes for rebuttal.
If I may, Your Honors, I would just like to briefly respond to the state's argument on the alternative means issue, specifically as to aggravated criminal sodomy. First, I'd like to point out that although the state argued in 2 of the other alternative means issues that they did not constitute alternative means, the state did not make that argument as to aggravated criminal sodomy, effectively conceding that they were alternative means and arguing only that the instruction was not clearly erroneous. Second, I would like to address the state's argument that this was invited error and that it is an instructional issue subject to that standard of review rather than a sufficiency issue. The first argument that I would make is that if that's the case, then aren't all sufficiency issues also instructional issues in the same way that this is? The issue is the instruction is not wrong. It's not wrong in this case. It's not wrong in a typical case. It clearly and accurately states the law. The problem is not with the instruction, but with the evidence given to support the elements of that instruction. So we know that not all sufficiency issues are treated as instructional ones. In fact, none of them are. They're all treated as sufficiency issues, and we apply that standard of review. The second is that all sufficiency issues would also be invited error. If a defense witness suggests the instruction, if a defense attorney suggests the instruction that the district court ultimately uses, and the state then fails to present evidence to support the elements of that crime has defense counsel then pulled one over on the court by saying, hey, give this instruction so I can argue on appeal that there was no evidence to support these elements. That's not the case in a sufficiency issue, and it's not the case in an alternative means case issue either. Unless there are further questions, those were the only points that I wish to make.
Any more questions of counsel? I see none. Thank you, counsel.
Thank you, Your
Thank
Honors.
you both for your arguments this morning, actually this afternoon. The court will take this matter under advisement. That concludes today's docket. This court will be in recess until 9 o'clock tomorrow morning.